persons having anything to do before the Honorable Justices of the Appeals Court, now sitting in Boston within the Commonwealth. Join name, give your attendance, and you shall be heard. Now, sit the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning and welcome to the Appeals Court. My name is Justice Peter Sachs. To my right, your left is Justice Suk-Young Shin. To my left, your right is Justice Andrew D'Angelo. Will be the panel for both of the cases we're hearing today. Each of the cases has only the appellant arguing, so we'll go right through, and I don't expect we'll be here for too long. We have read your briefs. We're familiar with the facts of the case, so I would suggest that you get right to your argument. Both of these cases are impounded, as you know, so please don't use any actual names. You can refer to the parties in whatever role capacity you want, but no names, please. So with that, I will call the first case, which is 22P944 SJ versus TS. Mr. Dwyer.
Members of the panel, Attorney Kevin Dwyer for the appellant TS. May it please the court, this appeal is based on a 209A order which was issued against my client in the district court. What's before the court at this point is a reconsideration of the district court order, issuing that order based on what I believe was an incorrect interpretation of the definition of family or household members. I do not believe that these two parties had the requisite relationship under 209A to entitle the plaintiff to a 209A order. These two young men were roommates assigned to live together by their university at the time. They were not married. They had never been married. They were not related by blood. They did not have a child in common. They were never in any type of dating relationship. So the only definition pursuant to 209A that may apply is whether or not they were residing in the same household. And I'd suggest that they were not residing together in the same household. And the case I cited was Silva v. Carmel, which is a Supreme Judicial Court case of 2014.
So do you think the holding in that case is relevant because the parties were sort of forced into that household situation because of a governmental agency? Or do you think that case holds because they weren't sort of domestic partners in any way?
Both. They didn't voluntarily choose to live together, much as the parties in Silva v. Carmel. They did not choose to live together. And I understand we're talking about a private college. So they did voluntarily choose to attend that college, but they didn't voluntarily choose to live together.
I'm sorry. So you think that matters? So if, say, they're sophomores and they choose their roommates and they live in a dorm together, do you think that's enough?
I think it's a different consideration at that point. Some college roommates could be household members. There was a case last month that the appeals court took up that involved college roommates where the 209A order was found to be inapplicable based on the behavior. That was KZ versus NF. That was April 14th, 2023. Appeals court case that left open the question and cited Silva v. Carmel that there's a question whether a 209A order applies in the context before us. The statute applies to household members, though that does not mean it applies to all people who live together. So I think I have a weaker argument if the two gentlemen in my case were seniors and they'd been friends for 3 years, and they decided, okay, senior year, we're going to live off campus, we're going to sign a lease together, we're going to pay our utilities together.
Or I'm envisioning a hypothetical where they choose each other as roommates, but they're still in a dorm. So would that make them household members because they chose to live together in a dorm room?
No, because I don't believe a dorm room has the same sort of household characteristics. Are they socially interdependent? Pursuant to 209.
So it's not the voluntariness of living together that matters. You're saying it depends on
No, I think that matters as well.
It does? Okay.
It does. And I don't think a dorm necessarily is a household.
Why? Because it doesn't have a kitchen, or what's the difference?
Well, they're not paying rent to a third-party landlord.
Well,
They're not
certainly
sharing.
that's part of their room and board they're paying to the college, somewhere in there.
Right? Okay, possibly. I mean, I understand the point.
So I guess the question is, what makes a household?
And so, right, and so the case that I cited, talks about, a family-like relationship. They live together because they were family.
Well, it also talked about socially interdependent relationship. I think that phrase was in Silva at page 22. So they don't have to be family. They don't have to be relatives by blood or marriage, because that's a separate category of definition of family or household member. What makes a socially interdependent relationship other than or in addition to choice?
They're choosing to spend their lives together. They're choosing to work together, to live together, to achieve family-like status. They're living together by choice. They are doing it because they're holding themselves out as a family, or they're living together.
So two people who are friends, again, not in a dating relationship, but they're friends, they sign a lease in a regular household, whole floor with a kitchen, et cetera. They fit into the definition.
Not necessarily.
So
It's a fact-by-fact case. It's a fact-by-fact case.
by fact case, what we have to look at is obviously the future. Is it the relationship between the parties that controls, or is it the household that controls?
The relationship.
So there's no in my hypothetical, again, they're friends. They've known each other for 5 years, they get an apartment together, they sign a lease with a third party. They still don't have that familial or dating relationship, but they have a friend relationship. Is that a socially interdependent relationship whereby they meet at least an element?
I think it would depend on how long they've been living together, for example.
Well, let's say a couple weeks or a
No,
couple months.
no. I think it has to be done on a case-by-case basis. I mean, if,
All right, well,
like I
we're
said,
probing to see where the line is and why. A year?
possibly.
Why? Why a year possibly, but
Well, if they
months,
if
no.
they decided to live together on their own voluntarily for more than a year, I think a court could reasonably find that maybe they're household members at that point, if they're sharing expenses and sharing bills.
But what if they do that all along, from the get-go? They've made an agreement that they're going to just be friends, but they're going to share all expenses, they're going to cook together, they'll have their separate rooms, but why is that not a household from the get-go?
It could be.
What about minor children? Let's say two friends live together, not married, not in any kind of romantic or dating relationship, and one of them has a minor child, or both of them have minor children. Are those minor children in a household relationship? They haven't chosen to live there.
Well, in the context of a 209A order,
Right.
could
One can seek a
seek one
209A
on
in the
behalf
name
of the child?
Yes.
I could see that, sure. I mean, I could see a mother perhaps asking that a 209A order be issued on behalf of her child, depending on how long they have lived together, what the circumstances of the living relationship is, what are the parties, how are the parties living, how are they paying their bills, are they living together, have they been living together, like the definition of a substantial dating relationship. What's a substantial dating relationship? I mean, that's really determined on a case-by-case basis. I mean, it's tough to put a black and white definition on. I just, going back to this case, two college freshmen who are just randomly assigned and there's no evidence of any prior relationship between these two young men. And they didn't decide to live together freshman year. They were randomly assigned, and there's an issue. There's a fight of some kind. and now one of them's in court on a 209A order. That's just, in my opinion, they don't have a familial type relationship that would fall under a 209A order.
Doesn't have to be familial. The statute says family or household members.
Or are they household members? And so the phrase, residing together in the same household, is there a socially interdependent relationship between the two? In the case that I cited, where the parties were not voluntarily living together, they were assigned to live together.
What if you're assigned
There's
by
no
your...
family-like connection between the parties. I'm sorry.
No, that's right. What if you're assigned, two people are minor children and are assigned to live together by their parents, or they're perhaps wards, their parents are, or they have guardians, and the guardians say, we're not going to live with you, but you two are going to live together. So the two people who are living together are not choosing to live together, but still it's no larger entity like a government agency or perhaps like LaSalle College forcing them to live together. Are they in a household because their guardians or their parents have said you're going to live there while you're away at school, whatever it might be?
I'm not sure. I'm not sure. I'm seeing this in the context of a 209A order. I'm not sure what one of the parents would be taking the child to court to get a restraining order against somebody else. Is that?
Yeah, against the other person who's living there. I mean, it seems apparent that you view your case and your facts as simple because they didn't choose together, but what we're probing is what kind of relationship makes a socially interdependent relationship, or whatever other test we might draw out of Silva to...
Right. So I think when adults are living together with children in your hypothetical, that certainly more resembles a household, more resembles a family relationship than the two gentlemen in my case.
Does the language in the statute regarding household potentially have anything to do with the structure itself? For example, where you're sharing the same, I'm going to call it a bedroom, like a dorm room, as opposed to two separate rooms that have a common area. Aren't there cases that talk about that in the definition of the household?
Yes.
So isn't it possible that the legislature meant when you're a household, if you're living in the same room together, because of that close contact, in other words, in a dorm, you're within 5 to 10 feet of that person constantly.
Right.
Then under that situation, you are a household member. But if you have separate bedrooms and just a common area, you're not household members.
I suppose, but I don't think so. I don't think that a dorm, and there are cases that talk about, did they share common eating facilities? Did they have that? There's no testimony in this case that they lived in a suite type of situation. I think that's what the court's suggesting.
I would agree. So my question is, since the evidence is, I think a fair inference at least, is they were in the same bedroom.
Right.
One bed on one side, one bed on another side, maybe there's desks. That's a common room. They're sharing it together. Under those other cases where they have separate kitchen areas, separate living couches, that's not a household. But in this one, it is.
I'm not sure if this one is a household, if they, again, I go back to the voluntariness of living together. I mean, I think part of a household is the structure itself, but it's also who's chosen to live there. And I think both considerations apply. The statute that we're dealing with talks about, families, family-like connections. And that are people that have chosen to live together as family or are related by blood. And sure, my guess is that this was just a dorm room with some desks. But again, if they were just thrown into this room together, that's why I suggested perhaps 258E is more applicable here. If there was a problem between
let's say
these.
this happened towards the end of the school year, and in the meantime, the two of them had become very close friends, did a lot of things together, ate together. Would that make a difference?
I think it might change the analysis if there was evidence that they had chosen to live together the
No, they
year
didn't
after
choose.
that.
It's the same facts here, but over the course of this school year, they become very close, and they make their meals together in the common room, let's say, regularly. Would that make a difference then?
Probably not, because I don't believe that they voluntarily chose to live together at the beginning.
I guess
so
I'm
at
not
the time
seeing
that
why
this-
that's so dispositive.
Because at the time this order is issued, the analysis is what was their relationship at the time the order is issued.
Right,
Not-
right,
Not
so
what their relationship might be in the future, but
No,
what's
so
their
at the time the
relationship.
order issued, they're very close at this point, we're assuming. Right, the order issues, say, in May, and by that point, at the end of the school year, they've become very close. So why is it dispositive that they were placed together in the same room by the university at the beginning of the school year?
Because they didn't choose to live together, and so there's no family-like connection, like the parties in the case that I've cited. They were randomly assigned to be in each other's space. They were not choosing to live together. So even if they got along toward the end of the school year, unless there was some evidence that they had moved and decided to move together to a different unit, I don't see how that would change the analysis. The district court judge has to make a decision on what are the facts at that time. What's the relationship at that time, not what it might be sometime in the future.
Anything else? No. All right, your time is up. Thank you very much for your argument. These are some fine distinctions we're grilling you about, and you bore it with good cheer, so we appreciate that.
Thank you.
All right, and the next case will be 22P 1002 ET versus JU. Ms. Kavanaugh?
Good morning, Your Honors. May it please the Court. My name is Angela Kavanaugh, and I have the pleasure of representing the appellant, Mr. J.U. Your Honor, this case focuses on a harassment prevention order which should have never been issued against my client. As Your Honors know, the law is very clear that there need to be 3 acts which were specifically willful and malicious that were aimed at the plaintiff below. Your Honors, this case has a plethora of issues, but what I really want to focus on is whether or not the acts that were alleged in this case were actually aimed or had the intent to be aimed at the plaintiff.
Ms. Kavanaugh, we, at least from my reading of it, we do not have the pictures and the videos in the record. So how are we to analyze whether anything in those pictures or videos are of a threatening nature?
Yes, Your Honor, and that is something that I did become aware of. My answer to this court would be that the video that was submitted, or screenshots of the video, were never sent to my client, were never sent to the plaintiff by my client. And these were screenshots of a video that were sent to mutual friends or coworkers that both of the plaintiff and my client knew. And thus, the video, or the screenshots of the video, were, for lack of a better term, not relevant to...
Well, let's assume that they depicted violent conduct
Well, I think,
by the defendant against the plaintiff in some kind of, fabricated manner using
and I think that,
Photoshop, or if that's not too outdated. Is it dispositive that he says he didn't intend them to reach the plaintiff? I mean, isn't it reasonably foreseeable that when you send something like that around to a number of coworkers about a different coworker, that one of those coworkers is going to forward it on and say, hey, look what he's saying about you?
No, I don't think it's dispositive. And I think based on the record of what we know, not only,
Just a sec, I'm sorry. Maybe I phrased that wrong. You said it's not dispositive. Are you saying it is dispositive that he didn't send them directly to the plaintiff? So it doesn't matter that he could reasonably expect that someone else, one of his coworkers, would forward them to the plaintiff?
I think that's what I'm saying, Your Honor. What the record explains is that not only did my client not have the intent for her to receive these screenshots of the video, but the plaintiff herself says in her testimony that she didn't believe or have reason to believe that he meant for her to see those.
One of her answers, again, I know there were a few answers she gave, but one of them says, I don't know. And I understand what your client says, but in a light most favorable to the plaintiff in the harassment order, we can put aside what your client said. So back to Justice Sachs' question. If those pictures or videos were of a threatening nature to the plaintiff, why isn't it reasonable to assume that your client believed she would see or hear about them? Based on the record. It doesn't matter what she thinks. It's what a reasonable person would think, isn't it?
Well, I think the reasonable person standard is whether the plaintiff had a reasonable fear of imminent bodily harm. And even if the court found that the screenshots of the video were so violent in nature, I think that they're described as being sexually explicit, her face on something that wasn't her. But even if the court found that, that those could lead a reasonable person to have fear, I don't think that that standard is met here. That the screenshots of this video, this one act, a video sent to, not the plaintiff, but to coworkers, mutual friends, that alone isn't enough to show that she would have a reasonable fear of serious bodily harm.
I did want to clarify that. So the screenshots of the video, that's something different than the lewd images that's referred to in the first paragraph of the affidavit, right?
I think they're the same. I think
Same?
my understanding was that a video was dispersed to coworkers, and the plaintiff took screenshots of that video. If we look at...
So the 20 images referred to in the first paragraph of the affidavit, you think that's the same thing as the video that's referred to in the third paragraph? I thought they were different, but we don't, she never actually submitted any images, right?
Right. My understanding was the images that were submitted to the lower court were screenshots of the video.
And that's the same thing as the 20 images cropped out of pictures from Facebook?
Well, Your Honor, I don't want to misspeak. I guess I couldn't be sure.
Okay.
I couldn't be sure, but what I believe that was submitted to the lower court were images of the video.
Okay.
But again, I think we have to go back to, even if the court was so disturbed by the images of this video, that wouldn't be enough for a reasonable person to fear serious bodily harm, imminent bodily harm.
I guess my problem, counsel, is we don't know that. I mean, there could be a video that is just so grotesque and violent that anyone who would see that video, as you just said, might be horrified by that. And that a reasonable person could be in fear of. Whereas if it's just a video, and I understand you're going by the record, of screenshots of explicit photos with her on an animal or whatever it is, that's bad, but it's not as horrifying as something out of a horror movie, Halloween or one of those. And I don't know how we can decide this without knowing what those pictures were or what the videos were.
Well, Your Honor, if I could get permission from the court, I could submit them after oral argument. But even if I wasn't permitted to do that, even if we consider that, Your Honor, even if we consider the screenshots, which I would argue, based on the record, were not so violent and volatile, based on what the plaintiff herself says, that she never felt threatened by him, she never was in fear of him. They had worked together, I think it was 4 times, had limited conversation based on just helping the patient. Based on her testimony alone, I think we can surmise that it wasn't that violent, that it was irritating, childish screenshots of a video. But even if the court said that that would be enough, that's only one act.
Sends the video to 20 different people on, one after another.
If
Not enough, a blanket text or whatever, she sends them repeatedly. Is that?
my clients sending them, you're saying? Well, I think in that case it may be different, but I
How
think.
do we know in this situation, based on the record, how it was sent to different people? It was sent to different people, we know that. Multiple people, but we don't know how, and I'm not sure that makes a difference. So I'm asking you, is it different if it's a text to 20 people, or is it different if they're separate text to 20 different people?
It's a good question, Your Honor. I don't think that it matters. I think that the subject of this act is this one video, whether it was blasted out to many people in one text, which we can do, or if it was sent to 20 different people in separate texts. I think that that in and of itself is one act. It's that one video, the dissemination of that video to people. Because then we could be in perpetuity of this video sending out here, there. I don't think that it would be fair to consider the sending of the video to multiple people as multiple acts.
Well, I was going to ask about a possible second act, but if you had another point to make about the first one, why don't you finish that?
No, Your Honor, that would conclude.
So in the second affidavit, the first act alleged is the inquiring of the children's babysitter, which, when I read it, seemed to me like she could reasonably fear, and maybe did fear, that that he was stalking her, that he was trying to find out her physical location, which he wouldn't need to do unless he was planning to do something to scare her, if not worse.
Yes, Your Honor. That paragraph, speaking about contacting the children's babysitter, I believe it was elaborated on in the testimony, but
It was, but I think your client, the defendant, elaborated on it, but the judge shouldn't have to believe his story about why he was calling up the babysitter.
And I might be incorrect, but I thought that there was some corroboration that, in fact, the child's babysitter was a child of a coworker of them when they were going to meet. And maybe I'm not remembering correctly.
I believe there was testimony to that effect, but how does that affect whether it was directed at her, although through a third party, and intended to and perhaps did cause her fear of bodily harm?
Well, Your Honor, if we look at not just the testimony, but the affidavit itself, the plaintiff is suggesting that my client was calling the babysitter to ask why she needed a babysitter that day, not where she was or was she going to be home at a certain time. It was why she needed a babysitter, which I would argue corroborates the reason that they were supposed to have a meeting with the lieutenant that day.
Well, asking why she needed a babysitter is the same as asking, where is she? Isn't it?
I would respectfully disagree. I think even with the statement in the affidavit, that's not enough of an act, calling to say why someone would need a babysitter. What is the malicious and hostile and intimidating behavior of asking why someone needs a babysitter? And again, I think that based on the plaintiff's representation of the relationship that she had with the defendant, it is clear that they were co-workers and nothing more. This wasn't some type of dating relationship or even a friendship of finding out where this person is. There was a meeting that day and asking, is that the reason for the babysitter and why isn't the meeting happening? But again, even looking at the conduct, I don't think this court would be able to find that that is an act that's willful and malicious, intended to cause fear of bodily harm, intimidation, or some malicious intent behind it, especially when it's just that statement in the affidavit. I don't think it's enough, but even as it's elaborated in testimony, the plaintiff herself didn't suggest that she had a fear that he was looking for her. So I don't think that should be considered an act, Your Honor. And the other statements that the plaintiff makes, it is clear that she has no fear of bodily harm. She's afraid of being reported to the Office of Emergency Services, that if she does a bad job, he's going to report her. That is the crux of this case. She was upset and maybe nervous that her job performance was going to be discussed or talked about with her management or administrative body. There's nothing in these affidavits that suggests, other than that childish behavior of the video going out, there's nothing here that suggests that this plaintiff had fear of serious imminent bodily harm. She says in her own testimony she never felt threatened by this defendant. They never had an ongoing relationship or friendship. It was clear that she, and numerous times in both of her paragraphs, saying that my client was encouraging people to get out while you can, to quit because of her job performance.
First Amendment argument, and I know the case law talks about fighting words and threats, etc. But what about, again, going back to the affidavit, the first paragraph, talking about lewd images involving extremely sexual conduct? Do you believe that those types of photographs, etc., are covered by the First Amendment, or would that be pornography sent out to many individuals?
I believe it's protected speech, Your Honor. I believe that especially because it was not the plaintiff herself, that it was clear that it was doctored imaging of her. I think that it's protected. I don't think that it's pornography that was dispersed. And Your Honor, I've thought about the court's feelings of a video of this kind and what the remedy would be, and it's not Chapter 258E. It would be something more of a tort claim of false representation, misrepresentation of a person and their being. I don't think that this is what the legislature was trying to protect for 258E. It is clear that there is a fear of bodily harm or imminent serious bodily harm, that the conduct was aimed at the plaintiff. I don't think that we should forget that these images, this video, was never directly sent to the plaintiff. In fact, none of the statements in the affidavit were aimed at the plaintiff. It was telling coworkers, get out while you can, telling coworkers, I'm going to report her to OEMS.
I'm failing to see how, from that first paragraph, photos of herself of images that are extremely sexual conduct and lewd, how in the world that has anything to do with her work performance? You would agree that that's a separate thing?
Yes, I would agree that it's a separate thing.
Isn't that something that the legislature was directly trying to prevent? That is harassment. I don't know if it's harassment in the legal sense, but you would agree that's some type of harassment.
Well, in the legal sense, I would agree that it's not. Is it annoying? Is it frustrating? Is it embarrassing? Yes, I think all of those things, but I think the case law is very clear that that's not what this Chapter 258E is for. So if I could just conclude.
Okay, why don't you conclude?
I'm sorry, Your Honor. Just in conclusion, the acts, they don't meet 3 acts, and they were never aimed at the plaintiff below.
All right, thank you very much for your argument.
Thank you, Your
That
Honors.
concludes our sitting today. I want to thank our court officer and our court staff for assisting, and we are adjourned.